Hello students, today we are going to revise the 5th chapter of Civics, the High Courts in India. We'll practice MCQs because again objective type paper, you have to be thorough with the content. Let's begin with the first question. How many high courts are there in India? So currently there are 25 high courts in India. Your answer will be A here. Which of the following union territory has a high court of its own? It is Delhi. Delhi is the only union territory which has a high court of its own. Rest, Daman and Diu, they have a judicial commissioner, and Chandigarh shared its high court with Punjab and Haryana high court. Delhi is the only union territory. So D is the right answer here. Third question. What is the purpose of appointment of additional judges in the High Court? As I told you in the previous video, judges of High Court and Supreme Court are appointed by the President. Okay. District Judge and Session Judge are appointed by the Governor of the concerned state, but High Court and Supreme Court are appointed by the President. So what is the purpose of appointment of additional judges in the High Court? To clear pending areas of work, to get the work done more effectively, to work in the absence of permanent judge, or to substitute a Chief Justice of High Court. So here answer is A. In case there is a long pending areas of work, so the President may appoint an additional judge for a period not exceeding 2 years. Okay, so A is the correct answer. Let's move to fourth question. Who appoints the judges of the High Court and on whose advice? Just now I've told you, appointed by the President. So we'll pick up the option with the President. So quite clear to us, yes, B, President on the advice of the Governor of the concerned state. So judges of High Court are appointed by the President on the advice of the Governor and in consultation with the Chief Justice of India and Chief Justice of High Court. B is the right answer here. Fifth question, what is the tenure of a judge of a High Court in India? Until retirement at the age of 62, fixed term of 15 years, until removal by the President, no fixed retirement age. For High Court, the person retires at the age of 62. And for the Supreme Court, the retirement age is 65. So here the question is about High Court. So A is the correct answer, until retirement at the age of 62. Now the sixth question. In India, a person is eligible for the appointment as a High Court judge. Must have been an advocate for minimum years of 10 years. So it is same for the Supreme Court and High Court. In case you have worked as an advocate, your work experience should be 10 years and above. Okay, so C is the correct answer here. Even the scenario-based question has been given. A shopkeeper owner is in a financial dispute with a supplier and both the parties are willing to settle the matter outside the regular court proceedings. How can they benefit from the Lok Adalat for a resolution? Lok Adalat means People's Court. And Lok Adalat provide us with the quick, inexpensive and easy justice. Because there are no legal formalities, you need not to hire any lawyer as well, and moreover the decisions are based on compromise. So it's always easy, it is always faster to provide justice. So D is the correct answer here. It will provide them with the speedy and quicker justice. Eighth question, Justice P.N. Bhagwati is known for introducing which progressive legal concept in India? Justice P.N. Bhagwati has given the concept of fundamental rights. No. Lok Adalat? Yes. Okay, so B is the right answer here. Moving on to ninth question, which of the following cases fall under the original jurisdiction of the High Court? Original means the power to hear and decide the cases at the first instance in the High Court. So what are the types of cases? State revenue? Yes. Cases related to marriage and divorce? Yes. Contempt of court? Yes. Issuance of writs? Yes. All of the above. So A is the right answer. All these cases fall under the original jurisdiction of the High Court. The 10th question. Which among the following is not a common function of Supreme Court and High Court under their original jurisdiction? So judicial review? Yes, it is by the Supreme Court as well as by the High Court. Issuing of writs? Yes, both are empowered to issue writs. Contempt of court, they can punish for the contempt of court, both of them they can do that. Center state disputes, it is only with the Supreme Court under the exclusive original jurisdiction of the Supreme Court, not with the High Court. So D is the right answer here. Now the 11th question, Which of the following statements is incorrect with regards to application of revisory jurisdiction of High Court? Under Supreme Court, we have studied that it can review its own decisions under revisory jurisdiction. But under revisory jurisdiction of High Court, it can call for the record of a case which has already been decided by the subordinate court. So under what circumstances it can call? Let's read the options. Injustice on the face of record, violation of principle of natural justice, arbitrary authority leading to wrong judgments, revising its own judgment. So the right answer is D, reviewing its own judgments, revising its own judgment. So under the revisory jurisdiction of the High Court, it can call for the record of a case from the subordinate court in case the subordinate court has done a grave injustice on the face of record, or it has violated the principle of natural justice, or it has led to a wrong judgment, not the revising its own judgments. So 12th question. Under which of the following jurisdiction a High Court can call for the record of a case which has been decided by the subordinate court? Just now I've told you it is under the revisory jurisdiction, so A is the correct answer here. Moving on to 13th question. Which of the following statement is incorrect with regard to eligibility to be a judge of the High Court? Should be an Indian citizen? Yes. You want to be a judge of the Supreme Court or High Court? Indian citizen is must. Should be a distinguished jurist in the eyes of the President? This clause is not applicable to be a judge of the High Court. It is applicable to be a judge of the Supreme Court, but not for the High Court. So B is incorrect. Let's read other two options as well. Should have been an advocate of a High Court for at least 10 years? Yes. Should have held judicial office in the territory of India for at least 10 years? Yes. So B is the incorrect option, but the right answer. Moving on to the second last question. Using its power of judicial review, a High Court cannot declare any law passed by the state legislature as null and void if it violates the spirit of the Constitution. No, it can. It can declare a law passed by the state legislature as null and void if it infringes the spirit of the Constitution. B option. Declare an executive order or any ordinance promulgated by the governor as null and void if it violates the spirit of the Constitution. It can. May withdraw a constitutional case from a subordinate court and deal with it or send it back with recommendation. Yes, it can. Declare any law passed by the Union Parliament as null and void if it violates the spirit of the Constitution. Yes, this High Court cannot. So D is the right answer here. The last question. Appellate jurisdiction of a High Court in criminal cases. That lies under civil cases and criminal cases. Here we are talking about criminal cases. Extend to A option, against the judgment of a session judge where the sentence of imprisonment increased 7 years. Yes. Against the decision of an additional session judge if the sentence of imprisonment exceeds 4 years. Yes. A sentence of death must be confirmed by the High Court before it is executed. Yes. So all of the above. So B is the correct answer. Okay, so that's it from my side. Still, if you need any help, so feel free to reach me, and do not forget to like and subscribe. Thank you so much.